This is Charter Local Edition. I'm Brad Pomerance in Long Beach. Today we are joined by Thomas Saenz. He is the president and general counsel of MALDEF, the Mexican-American Legal Defense and Education Fund, whose focus is what?
Our focus is on promoting the civil rights of all Latinos living in the United States, but really more broadly, we're about ensuring that the Constitution and its values and principles are reflected in our laws for everyone.
Let's talk about a constitutional matter that is currently before the U.S. Supreme Court. The case is known as Evenwel versus Abbott. I'd like to get a general sense of the case by starting to ask, what is the current law today when we draw districts and who is included in the calculation of how many people live in each district?
So the current law, established by a case a couple of decades ago in the Supreme Court, is that states can decide how to draw districts to equalize their populations. There is a constitutional mandate that districts at the state legislature, city council, school board, Congress within a state be of roughly equal population.
I actually remember, I think it was in the 60s, there was a case coming out of California where our state Senate districts, we couldn't have more than one senator from a county. So LA had the same number as Alpine.
Yeah, so that's what you saw before that case, which established the so-called one person, one vote doctrine. Right. You saw that kind of disparity in lots of states where the upper house, the Senate, usually was based on geography rather than on population.
Got it.
And what the Supreme Court decided in that one person, one vote case is that you can't do that. You have to roughly equalize population in these districts. And that's why after every census, we have to redraw the districts because populations have shifted.
But who's considered part of a population, that equalizing population?
The practice everywhere these days is you use the total population.
Okay.
Because that's what the census gives you. The census counts every person, no matter their age, no matter their status, no matter any characteristic.
Documented, undocumented, children, adults.
Every person who's living in a household gets counted in the U.S. Census, and that's the data that's then used to draw the districts every 10 years.
So in Texas, a Republican Party official named, I think, Sue Evenwel, brought a case, and she challenged the inclusion of every single person as part of that population count. What has she been seeking?
So the Evenwel case, as I refer to it, because I don't think there's anything even or well about the case,
fair enough,
as you'll hear. But the Evenwel case contends that instead of using total population, the state of Texas, and by extension, if the Supreme Court rules in her favor, everyone across the country must use instead eligible voter population to equalize districts. So you would completely discount anyone who is not an eligible voter. At minimum, that means anyone who's not a citizen. It also means anyone who's under the age of 18. They would not be counted at all in drawing state Senate districts, state assembly districts here in California, school boards, city council, even potentially congressional districts within the state of California or the state of Texas as involved in Evenwel itself.
But with regard to congressional districts, U.S. congressional districts, as I understand it, I think it's the Constitution that says that the number of seats shall be apportioned based upon total population. Yes. So we look at each state population and that's how we apportion. Am I right?
That's correct. So after every census, the first thing that happens is we reassign House districts so that population changes between the states are reflected in their representation in the House of Representatives. And so for example, ironically, coincidentally, the state of Texas was the big winner after the last census in 2010, where they picked up 4 new congressional districts, increasing the size of their delegation. Other states lost districts and reduced the size of their delegations in the House of Representatives. And you're correct, the 14th Amendment of the Constitution now establishes quite clearly that in making the decisions about apportioning the House seats among the states, you must use total population. And there's nothing the Evenwel case or the Supreme Court could do to change that because it's directly written in the Constitution.
So upon what is the plaintiff basing her argument? Is it the silence in the Constitution, if there is silence, on intrastate apportionment?
That's correct. There is nothing specific in the Constitution or in the 14th Amendment about how you draw districts within a state. And that's why the situation that you described earlier, where state Senate districts could be based on geography, existed for so many, many decades after the 14th Amendment was adopted after the Civil War. So nothing specific in the Constitution. But the irony is the Evenwel plaintiffs used the same amendment, the 14th Amendment, to argue that equalizing districts based on total population is unfair to voters.
Because?
Because a voter who's in a district with fewer eligible voters, but the same population as a neighboring district, their vote counts for less.
But the elected member is still having to represent children and non-citizens.
That's right. We
give them services.
Draw districts based on total population, we are basing districts on constituents. Who is the elected official serving? And there's great reasons to do that. Elected officials, whether they're in Congress or the school board, part of their job is to respond to constituent concerns and needs.
But using that analysis, then why shouldn't we then just rely upon those who turn out to vote?
Well, that's part of the problem, is this notion that every vote can be equalized, the strength of every vote can be equalized, is ridiculous, because you can't ever get to equal because of turnout. You could have two districts with the exact same number of registered voters, but the turnout in any given election is going to differ. Maybe because one district has an incumbent and people feel as though that person's going to be reelected no matter what, and there's a contested race in the other. So you can never end up in a situation where every vote is equal in that sense.
So I recall from my history lesson that African American slaves were deemed 3/5 of a person for purposes of apportionment. And that was specifically eliminated through the 14th Amendment.
That's exactly why the 14th Amendment specifically addresses the use of total population. Every person counts in apportioning House seats among the states. It was to repeal the 3/5 rule that you remember from civics. And that was the abominable compromise that was made when our Constitution was originally adopted in the late 18th century.
But I guess, could you say, well, we're not creating 3/5 a person, but 0/5 a person.
That's exactly what we're doing.
But is that objectionable per se?
I think it clearly is objectionable. Every constituent should count. They all have the right and, in some cases, the need to have the services of an elected official, whether it's representing their views on legislation or, in some cases, just getting the assistance of a congressional office or legislative office in what they personally need.
Could the court say, well, for total apportionment between the states, we leave that as is, but each state can decide? Would that be a defensible constitutional position? I mean, I know I'm asking you to argue against yourself, but could you see that happening?
It is possible that the court could make a states' rights decision. The state of Texas, through Governor Abbott, that is defending the Evenwel case, has basically asserted a states' rights argument. The Supreme Court, you have said previously that it's at the discretion of the states. We, the state of Texas, have decided to use total population. Enough said, therefore the Evenwel plaintiffs lose. That's their defense. So it's conceivable the Supreme Court could pick that up and say, it remains the law that you have discretion.
But could it be narrow enough that 49 other states simply decide that, okay, Texas does what it does and we're going to keep it with total population?
It is possible. I mean, I think Texas would still stay with total population in part because it is so difficult to draw equal districts based on any measure other than total population.
I'd love for you to come back. Fascinating conversation. His name is Thomas Saenz. He is the president and general counsel of MALDEF. My name is Brad Pomerance, and this is Charter Local Edition.